There we go. We're recording now. I can put my note up and hi, everybody. My name's Jerry Prosser. I'm the Director of Care Services of the ALS Association, DC, Maryland, Virginia. I want to thank you for coming to our webinar today. This is our Mid-Atlantic webinar series, and I'm always appreciative of everybody who shows up. And just a couple things before I introduce Erica and get everything started. I want to let you know, mine's at the bottom of my screen, you guys, but there's, if you have questions, we will address the questions at the end of the webinar. And there is a little, like I say, mine's at the bottom. Some people have told me it's at the top of their screen, but a little Q&A. And if you go ahead and go ahead and put your question in there, we will definitely address them at the end of the webinar. So I think everybody's got, we were talking a little bit about the weather earlier. It's oddly warm here in Virginia Beach. It's cold in Cleveland. So we've got a whole mixture. And if any of you have snow, really, I just want like 2 inches, just one day. Please send it down. My grandkids would love it. So with that being said, Erica, thank you so much. I want to introduce Erica Apellis. And Erica serves, and I'm going to read this. So here we go. Erica serves as counsel in the Estate Planning and Probate Practice Group and Business Department at McDonald Hopkins Law Firm. She's a passionate estate planning attorney who advocates for her individual and family clients. Erica's practice focuses primarily on traditional wealth and estate planning administration and trust and probate administration and litigation, including drafting wills and trust, advising on fiduciary obligations, and planning for probate avoidance. Erica's experience also includes assisting individuals and families with elder law and special needs planning issues, including Medicaid application and compliance, long-term care planning, and drafting trusts to comply with public benefit requirements. Erica earned her Juris Doctorate from Western Michigan University Cooley Law School. Prior to that, she earned her Bachelor of Arts in Psychology with a minor in Sociology and Art History from the University of Massachusetts. Erica is passionate about women in leadership and serves as the Vice President of FDCC Ladderdowne Cleveland, which is dedicated to empowering women attorneys to serve in leadership roles. Erica, I want to thank you in the beginning. I'm going to also thank you in the end. Really appreciate taking your time out of, I know you've got to be busy, taking your time out of the day and speaking to us. So what I'm going to do is I'm going to slowly exit off stage and let you take over. Once again, guys, questions in the question and answer, and we'll get to them all at the end. Thanks, y'all.
Thank you so much, Jerry. And I just want to, before I start my presentation, I just want to give a big thank you to all of you for being here today. And thank you to the ALS Association for having me. I appreciate the invitation, and I do really enjoy having these opportunities to talk to all of you and give you some insights and some guidance on how to start planning or how to amend your estate plans if you already have one in place. Just give me a minute. I'm going to share my screen and then I will get started. Okay. Okay, so today, as all of you saw in the invitation, today's presentation is Estate Planning Essentials and how we're going to start our new year right by creating or amending our estate plans. I am, as Jerry introduced me, and I am an attorney at McDonald Hopkins. I have been practicing for about 14 years now. My practice focuses on estate planning and administration, as Jerry indicated. We're a full service law firm, so I work with individuals as well as business clients. And I truly only focus on estate planning and administration. And I also do assist clients with charitable planning and business succession planning. I have had ALS in my family, so that is really the primary driver to me staying involved with the ALS Association and really helping all of you and your families get through difficult situations, difficult times. ALS is just, there's no other way to describe it other than it's a tragic, awful disease and progressive illness that is stressful and overwhelming. And I really enjoy helping families get through those difficult situations and helping make the situation a little easier. It will never be easy, but we can make it a little easier with some proper planning in place. And just a disclaimer that I give with all my presentations, my job as a estate planning attorney and as a planner, I talk a lot about death, and I talk about sensitive topics and topics that we don't like to talk about every day. So I apologize that some of the discussions are a little morbid and we do talk about difficult scenarios. It just has to happen, and it's something that will make life less stressful and easier the more we talk about it and the more we plan. It's not those sunshine and rainbows topics that we like to think about, but it is important and necessary for your family and friends to make things easier. The focus of estate planning, most individuals or families focus on the death side of planning, but I like to focus, especially with ALS being a progressive illness, I really like to focus on the lifetime planning. That's the critical planning that makes sure that we are taking your needs and your concerns and your wishes into consideration when we create that plan. So I always segment estate plans in two ways. There's lifetime plan and a plan should something happen. And then a warning, if I talk about medical things, my terminology might not be 100% correct. I'm not a doctor, I'm a lawyer. So I will talk about some of that when we talk about medical powers of attorney. This is just a guide as to what we will talk about today. We're going to talk about your lifetime documents, your estate planning documents during your life, your estate planning documents should something happen. We'll touch a little bit on some tax planning, gift planning, and just some practical pointers when you are going through your planning of what to look out for, what are some things that we can do just to make things a little easier and to plan ahead. So I really like to give this outline and this trajectory to clients and show you what the estate planning process looks like. Most clients who come to me who don't have an estate plan, they're overwhelmed, they're stressed out, they may be dealing with a difficult situation, and in your situations, it's a difficult diagnosis. You're overwhelmed, you don't know what to do, you don't know what needs to be done. And just giving this process that we take in the estate planning world, it helps you guide you and show you that it's not overwhelming. We try to make it as simple as possible. So when I meet with clients, we have an initial conference that can be with the client, their spouse. Sometimes we have other family members, but typically it's a client and their spouse. We talk about the need for planning, what's driving the planning, what are your concerns, what are your wishes. We talk about family dynamics, which can be difficult conversations as well. They can be hard situations to deal with, and we'll talk about that. We'll talk about, do you have relationships with all your family members? What do those look like? And things like that. That helps me better understand the way we should structure your estate plan. I will send you a questionnaire and a net worth statement that you'll complete and send back to me. And then at that point, we will either start drafting your documents if we have enough information, or we will have a conference to chat about some questions I have or some additional information I might need. Then we will draft your documents. I send them for my clients. I send them out by email. I can mail them, but it's typically just by email. You'll review them on your own, and then we'll set up a conference to talk about them. Typically nowadays after COVID, it's typically a Zoom conference where we're talking about how the documents function, what do they look like, what provisions did we put in, why are those provisions in those documents, and we'll make changes if you have any changes to your documents, and then we'll meet again in person this time to sign your documents and execute them, and then we will send you a full set of originals. We keep a full set of originals for safety for all our clients in our document vault, just to make sure nothing gets lost. The biggest misconception I hear, and I have that down the bottom, the biggest misconception is that, okay, I don't have an estate plan, but that's okay, I'll get by, things will be okay. Even if you don't have a plan written out, or if you handwrite one on a piece of paper, that's probably not valid in most states. Even without one, there is one for you. Every state has state statutes that dictate where your property goes if you pass away without a will or without a trust. So those statutes typically function in a way that they would pass assets to your surviving spouse. If you have one, if you don't have one, to children. If you don't have children, maybe if you don't have children or grandchildren, then up to parents and back down to siblings. And that's where we start seeing the question marks with clients of, oh, I didn't realize it could go to siblings, or it could go to nieces or nephews that maybe you don't have a relationship with. Maybe they live in another country, or they live far away and you never see them. So that's what is the focus of estate planning. It's making sure that when you have a plan in place, things go where you want them to go, and the person making the decision is the person you want in place to make those decisions. The next slide just gives a general overview of how your documents function and how they work. So we have, as I said before, we have lifetime documents, and we have documents that function after death. Your lifetime documents are your trust, your durable power of attorney, your healthcare power of attorney, your living will, and your HIPAA release. So those are all used during your lifetime. With ALS diagnosis and living with ALS, it's important to have these documents because they prevent emergencies where we don't have anyone to make decisions. They prevent the need for guardianship. So these documents, as I've said before, are critical to having an estate plan in place that functions and works both during your lifetime and at death. The documents that are used after death are your trust, your will, beneficiary designations, and a memorandum of personal property. You'll notice that on my chart that the only document that exists both during lifetime and at death is your trust. And that's important to note because that is the reason why in a lot of states, in a lot of situations, and with a lot of families, a trust does make sense from an estate planning standpoint, because you can transfer assets into it during your lifetime, use those assets as you want, as you wish, and then after death, those assets are already in the trust. They've already been transferred in. So there's no second step that needs to happen if something happens, if you pass away. You already have those assets funded into that trust. So it skips that step of needing to administer and move anything. And it's especially helpful with families where you have a surviving spouse who needs to pay bills, children who are young, who have bills that need to be paid maybe for school or college. So it's really important that access to assets immediately after death during an already stressful time that can be overwhelming. So it just makes things easier for the family who is wrapping up affairs and handling things. And I just also like to note, without a trust, and if you are having traditional probate administration, you might not have access to assets for 1 to 2 months if you have a probate administration with just a will. It might take that 1 to 2 months to have someone appointed who can then access assets. And with a with a beneficiary designation, that is the common misconception is that it's instant. It's not instant. It can take up to 2 weeks, maybe even longer, depending on the financial institution, because we have to wait for a death certificate, and the financial institution or life insurance company typically has paperwork that needs to be completed and approved by their legal department. So sometimes that can take longer than you ever expected or anticipated. So that's one thing just to keep in mind as well. We'll first talk about your lifetime documents, and that will really be a good part of our discussion. And it's a focus because with a progressive illness like ALS, and I've seen it myself in my own family, it's very important to make sure that you have those decision makers nominated. And the critical reason is we want to make sure that your wishes are met and that you have someone in there making those really critical and really personal decisions that you trust, that you know. In a guardianship situation, sometimes those situations become litigious and there's fighting, and sometimes a court steps in and does not like the fighting and the litigation, and they will sometimes appoint a neutral person that you might not even know. It's could be a lawyer, it could be a social worker. It's typically someone that you're not familiar with. I know personally I wouldn't want someone that I don't know managing my affairs and making healthcare decisions for me. So that's why these lifetime documents are really critical and important for you to put in place as soon as possible when you have a diagnosis and are living with ALS. It's important to put these in place as early as possible. So your first document is your trust. That allows your assets to be managed efficiently and according to the way that you outline in your trust document. Your durable power of attorney for finances, that allows someone else to make financial decisions for you, allows them to pay bills, to sell houses, to transfer assets, do whatever they need to do to live life the way that you had lived life before and manage your affairs properly. That document is effective immediately. We typically draft financial powers of attorney to be effective immediately now. There's a couple of reasons. It just makes it a more efficient process. And a lot of times if you have to prove incapacity, that can be difficult, and some physicians don't want to get involved in those types of decisions anymore. Healthcare power of attorney, that allows someone else to make healthcare decisions for you. It does require incapacity. So with ALS, you would have to be fully incapacitated for someone else to be making those decisions for you. And your living will is your document that outlines your end of life decisions. It's not the same as a DNR. A lot of individuals assume that does include a DNR. It's not. A DNR is a medical order that you will typically execute with your doctor at the hospital or at a facility. And it's important to keep in mind also with ALS, it's an incredibly expensive disease. It's stressful for families because of the severe expense of the disease. And that's why this planning is so critical, especially the lifetime planning, because you do not want, on top of the expense of ALS, you don't want to have the additional expense of a guardianship that is court fees, attorney fees, annual accountings, all your finances become public record and they go on the public docket. You just really don't want that to all be out there and have the additional expense of a guardianship proceeding when you can completely avoid it with these documents. We'll first talk about, and then also we execute HIPAA releases. And like I said before, we try to avoid guardianships. I really like providing this chart for trusts because trust can be difficult to understand and grasp how they function both during your lifetime and at death. This chart really does a good job of showing the differences. So your trust is really during your lifetime an incapacity document. So while you have capacity, you manage it, you do everything, they're your assets, you handle them. If you become incapacitated, it allows for someone else to manage those assets for you if you cannot do so. They're still your assets, still your money, still your things. Someone else is just helping you manage those, similar to a power of attorney, but within the restrictions that the trust has. So they can only manage it according to how the trust document outlines that. After death, it becomes a control of your legacy, a distribution of your assets, providing to your spouse, your children, grandchildren, siblings, charity. It really distributes all those assets, and it can be in different ways. It could be immediately, or it could be with certain restrictions. Your trust during your lifetime is revocable, meaning you can change it, you can revoke it, you can make any changes you want to it during your lifetime. After death, it becomes irrevocable. So your beneficiaries can't come in after you pass away and change things and change beneficiaries and change how much they're getting. It's irrevocable. They are stuck with the terms that you set up while you were alive. Your trustee during your lifetime is either you or your successor trustee. Your successor is your backup trustee. So who did you name? Typically it's a spouse or a child. Who did you put in place to manage those assets if you can't do it during your lifetime? And then upon death, it's again your successor trustees. The beneficiaries during your lifetime, it's you, the grantor, the person who set up the trust. And after death, it could be your spouse, your kids, your grandkids, heirs, any other heirs you might have, named individuals who are friends, family friends, charities. It's really, there's no limit to who you can name and how you can divide your assets of your trust. For the assets during your lifetime, you can transfer those assets in and out. So you can fund the trust, pull assets out, however you want to manage those things. After death, your assets that are in the trust remain in the trust, and there might be additional things that pour into the trust after death. So a life insurance policy is the best example. Maybe you have the trust designated as the beneficiary. After you pass, that would pour into the trust and become a trust asset. The revocable trust terminate. The termination during lifetime is revocable, so it can be changed at any time while you're living. And after death, it's your decision how it terminates. So you could have a trust set up where it goes to your children and they get the money outright and the trust terminates immediately. Or if you have younger children who are minors, or younger children who are in their early 20s, who you don't want managing any assets just yet, you could provide for them in staggered amounts at certain ages, or hold it in trust for their lifetime, just depending on the children, their maturity. Maybe they have some other issues, mental health issues, that make it difficult for them to receive assets. So that might be mental health, and maybe gambling addictions, things like that are typically reasons why we would hold assets in trust for life, or just tax reasons if there's a good reason to hold it in trust. There's two types. There's a trust agreement and a declaration of trust. Trust agreement is a situation where you are creating the trust, but maybe you're naming a different trustee. It can be revocable or irrevocable. So sometimes we set up irrevocable trusts. It's usually for gifting purposes. But in most family situations, most dynamics, it's a revocable trust that can be changed. And then a declaration trust is where you're declaring and have a trust set up for yourself, and you are the trustee of it yourself as well. These are just some of the roles that we see in trusts where we name individuals serving in these different roles. So the person setting up the trust is the grantor or the settlor. The trustee is the person whose job it is to administer the trust, to take the money, distribute it out, pay bills, pay expenses, and distribute it out to the beneficiaries in the manner that the trust outlines. Sometimes we'll add in investment advisors or business advisors. That's typically in situations where there's higher net worth of assets, or where there's a closely held business that someone might own. We'll put in a business advisor so that business can continue to run if there's incapacity, or the need for running that business after death to make sure that the business can be properly managed and either transitioned to the next generation or sold. And with minor children, we will many times have a children's advisor who will work with the guardian to ensure that the trust distributions are distributed properly and that the children's needs are met while they are minors or in college when they have expenses. Trust protector, we don't put that in every trust, but sometimes we'll add that in to appoint successor trustees or to provide flexibility for adding beneficiaries or changing distributions if we need to in the future. But that's typically a provision that we add into typically an irrevocable trust, but sometimes we'll add it into revocable trusts as well. These are some of the reasons why individuals and families will have trusts. It might not just be about high net worth or wealth. It can be because they're minor children and young adult children who can't receive assets yet because they're minors, or who should not have a large amount of assets because they aren't responsible enough to handle those, or there's a fear that someone might take advantage of them because of the assets they're receiving. There's also privacy. So a trust keeps everything private, keeps assets out of probate. When things are kept out of probate, it's not on a public docket that everyone can see and see how much someone is inheriting. Business interests are we typically have a trust when someone owns business interests, because a trust becomes a good vehicle to transition those business interests during incapacity or upon death, and you can run the business as it was always run, or sell the business if that's needed for liquidity. We also sometimes use trust for lifetime gifting, again for incapacity planning, which we've talked about. For blended families, we will use trusts where there's a second or third or a subsequent marriage and the current spouse is not the parent of not the children's parent. We'll use trusts, and the driving factor behind that is to make sure that those children are not disinherited by that second or third subsequent spouse, that those children still receive something under the trust and that they are protected as well. And many times it's because of net worth or estate tax planning purposes why we will have a trust. There's also, we with most families will use what we call a family trust. It's a trust it's a single trust for the family. Both spouses are trustee. It could either be for the surviving spouse or maybe for the children after the surviving spouse's death, or grandchildren or brothers, sisters. It could be for any family member after the spouse's death. Traditionally, these family trusts will only use these when you're under the estate tax exemption. So currently it's about 13.61, approximately 26 million combined. We'll use these trusts. If you're over that, we'll use individual trusts. Children's trusts, it could be when we have a trust for children. We will many times, if the children are minors, hold the money in one big giant pot of assets, one big account, manage it for the kids while they're young, pay for the things they need, and then when they become a certain age, split it into separate trust shares and distribute it to the children when they are ready and able to manage those assets. Special needs trusts are also something we consider in when we do planning. We many times deal with families who have disabled children with autism or other disabilities, and they might be on public benefits, or maybe they anticipate in the next couple years they'll be on public benefits. We will add language into our trusts to hold that individual's trust share separately and make sure it has all the language in that trust share that they don't lose those public benefits by having this trust account and this trust share, that it doesn't kick them off the benefits that they need. Many times those public benefits aren't accessible if someone has assets. So many times we try to make sure that we have that language in there, even if we're not sure that they will definitely go on public benefits. We just try to have it in there as a backup. It's just important to talk to your family members about this. You might have grandchildren who have a disability. It could be a niece, a nephew. So it's just important to have those conversations and just understand, not only for your own planning and for what you need, but also think about who you're giving the money to, and are you going to affect something in their lives as well. Just important to remember, some people have a misconception that trusts protect assets from creditors. Most trusts do not. And there's asset protection trusts that do that. We use them in really limited circumstances. They're not used every day. They can be, depending on the state, it can be pretty rigorous to set one up, and you have to typically sign affidavits that you're solvent. So they're not something that's commonly used. I just like to bring that up so you don't have a misconception that trusts are somehow not subject to creditors. So this next slide, we're getting into the most important topics. They're not the biggest documents. They're not the documents that are glamorous and that we sometimes look over in the estate plans. Individuals don't realize how important they are because they seem like a simple document, but they are really the most powerful documents and the most critical documents, especially with families with ALS. These are the documents that are going to allow your family members to step in and help you and to make decisions and help you in a time when you might not be able to do that. So these are the ones that I always say, if you're going to set up an estate plan, you need every document, but these are the most critical when you have a progressive illness, where you know that you have a diagnosis and it will progressively progress in such a manner that at some point you won't be able to manage your own affairs. Oops. I apologize if the screen went black. Let me log back in. Am I still sharing my screen?
Yes, we can see the side, all your slides, but so if there's a way to make it big.
Yeah, I'm sorry. Now
No, there you go. There you go.
My apologies. My computer logged me out. So the durable power of attorney is really one of your most important documents, like I was saying before my technical difficulties. So your durable power of attorney names agents to act on your behalf. This document's critical because if you become incapacitated, it gives the person authority to make those financial decisions for you. They can step into your shoes, do your banking, write your checks, make those decisions that you might not be able to make anymore, or maybe, and usually with ALS, it's typically you physically can't do it. It might be you can guide them through the process, but maybe you can't sign checks anymore. You can't maybe physically get to the bank anymore. So that person will really be your right-hand person to help you do those things when you are unable to do so. We typically draft, and every state's a little different, but we typically draft these to be effective immediately. It allows that person the seamless access to pay bills, do those things, make gifts, do things that you need help with. It can avoid the need for guardianship proceedings. So that's the most critical, is keeping your financial life private. That's typically very important to most people. is keeping everything private, and so not the whole world doesn't know how much you have in your bank account. And it's important to consider to look at these documents carefully if you have one in place. Make sure it has everything you need in it that allows you to live your life how you live it now. So the best example of this is not all powers of attorney allow gifting. Sometimes it's a risk we take. Sometimes it's, do we want your agent to be able to make gifts? But if you on a yearly basis are writing checks to your children or grandchildren as Christmas gifts, you might want that to continue, and you might want, in your incapacity or your inability to write checks, you might want those checks to still be able to be read. But if your power of attorney doesn't allow that, your agent will not be able to do that. So it's very important. That's just one example, but it's very important to make sure that you are including all the provisions that are important to continue your financial life the way you live it now. Next is your healthcare power of attorney and living will. So with most people, yes, we have one. It's very short, very simple. It doesn't say a whole lot. It might, typically most states make you have the specific language about artificial nutrition and hydration, but other than that, it's not very customized. With ALS and other progressive illnesses like MS and other diagnoses that are similar, you can include custom language and you can really customize these documents so that it does spell out all your wishes for your healthcare and your treatment should you be unable to make those decisions and those end of life decisions. So your healthcare power of attorney names an agent to make those healthcare decisions for you. And important, every state calls these something different. So if you're not in Ohio we call them healthcare powers of attorney. Some states call them healthcare directives. They're the same type of document. There's just a different name for them. Like I said before, critical document when you become incapacitated, again, avoids the need for guardianship, and it provides that guidance. With ALS, you can include the medical interventions that you want or don't want. Can include allowing, stomach pegs for feeding for artificial nutrition, feeding tubes, ports that you might need for medical treatments, artificial hydration, tracheotomies, mechanical ventilation or ventilators. You can dictate all of that in these documents. So it really depends on, and these are difficult decisions. These aren't easy decisions to make, but the more you spell out in these documents and the more you outline for your agents, it actually makes those decisions easier for that person. And it might not be an easy decision for you, but it is one that is important to think about. So your family members have an easier time making those critical decisions when you can't do that. And with ALS, I always talk about, these are only decisions that are made when you can't communicate, and you can't communicate in any fashion. So you might be able to communicate not by talking, but you might be able to communicate through a letterboard. You might be able to communicate by squeezing your hand, yes or no. One squeeze yes, two squeezes no. That might be how you communicate. Maybe it's as little as blinking your eyes. Same thing, one blink yes, two blinks no. That might be how you communicate, and that's still a way to communicate your wishes. So that's something that you want to keep in mind is don't think about this as a loss of, don't think about this process and this planning as completely losing all control. You will still be in control of your decisions as long as you can do that. So as long as you can make decisions in some fashion, you will be doing that. But this does come into play when you are not able to make decisions in those manners. So just keep in mind that we can make these documents as custom as you like and really take into account all those interventions that you may or may not want. It's a very personal decision on what you decide. And now we'll talk about the documents after death. again, it's your trust, your will, beneficiary designations, and your personal property memorandum. Really, just doing this planning makes it easier on family. It's a more seamless transition of assets, and it just makes a difficult time less stressful for family members. And I have seen that firsthand. You know, I've worked with ALS families, and the one thing I hear is, wow, it was very easy, and we didn't have to worry a lot about accessing money and accessing assets. It was all there. It was all set up. All I had to do was move a few accounts, and I already had some accounts in the trust. So that is the biggest benefit, is that it's an easier process. Your will, if you have a trust, your will becomes very simple. Your will serves as a mechanism to pour assets into your trust. So if there's something left out, your will make sure that it gets into your trust. If you don't have a trust, your will outline who gets what property. Now, unlike a trust, a will cannot put strings on and attach strings to assets or attach conditions to receiving assets. All that happens is your will moves money from yourself, you know, in your personal name, to someone else. That's all that can happen. So if you want to give to minor children at certain ages, that is really only able to be accomplished through a trust. It's filed with probate court, so any assets flowing through a will do become public record and are administered with the probate court. Your executor will administer those assets. If there's no trust, the court oversees all the distributions and manages that. You might name guardians for your minor children in a trust, and it gives, in your will gives your fiduciary all the powers they need to transfer assets, including real estate and financial accounts. So a lot of comments I say, you know, I hear are, I don't have a will, I don't have a estate plan. It's not a problem. I have beneficiary designations. It's really not an issue. It's very rare that you have beneficiaries on every single account. So there is always something that's left out. So you're risking that, and you're risking someone receiving your estate, like I've said over and over, someone receiving your estate who you don't want to inherit under your estate. Beneficiary designations, I love them. They're an incredibly powerful tool. They allow you to transfer assets without the need for probate. It's basically by operation of law, assets pass from owner to the next owner. It's important, though, to use these in conjunction with your estate plan. So when I work with clients, I always work with them on their beneficiary designations and TOD, PODs, along with their estate plan, because it's important to look at everything as a whole, not in segments, to make sure everything functions together and that it makes sense from an overall estate plan purpose. And it's important to know, most people don't understand that these designations, while they're amazing and avoid probate, they also override your will or your trust. So the best example I can give of that is, in your trust, you might have, to my daughter Erica, everything outright, or everything at age 25, say. So Erica gets everything at age 25. If you take a investment account and name Erica on that investment account, she'll get that money right away, and it won't ever pass through that trust. So that's just something important to consider, is when you're naming beneficiaries, you have to be strategic about it and know how you're setting everything up. You can also name your trust as your beneficiary. So that's a tool we use a lot of times, especially with minor children, to make sure everything gets funded into that trust for those small children. There's different types. There's in Ohio, we have an amazing tool. I use it all the time with clients. It's a transfer on death affidavit for real property. Not every state allows this. This allows your real estate to be transferred by beneficiary designation. So you can do it in a couple ways. You can transfer it to an individual, or you can transfer it to your trust upon your death. So that makes ownership during your lifetime very easy. You can buy and sell property, and you don't have to deal with a title company asking about your trust. But at death, it goes right into your trust, so it makes administration really easy. So it's a very powerful tool. Not a lot of states have this. This is why states like Florida and Ohio, many times we will place real estate into a trust, or we won't, and we'll just allow spouses to own it jointly until the death of the first spouse. Registration and beneficiary form, that's just corporate ownership. So a corporation, an LLC, a limited partnership, a general partnership, all those types of entities, you can name a beneficiary. Payable on death, transfer on death, banks and investment accounts, you can name PODs and TODs. And then 401ks, IRAs, pensions, life insurance, you can name beneficiary designations on all those types of accounts. And then your memorandum of personal property it's a standalone document that I typically have my clients maintain on their own. It's just a list of the things you collect. It could be art, it could be cars, cars are titled, so you could name a car, but you'd still have to change the title. It could be collectibles you have, it could be your china, it could be gifts you received over your lifetime. It could be just anything small like jewelry. Jewelry is a good example of one that's very common. Jewelry or some sort of collectible. You make a list and you name who gets each one, and then you ask your trustee to honor that list and to carry out those wishes that you had. It just makes that administration of those small things much, much easier. So for taxes, I'm not going to spend an enormous amount of time about in this section. I will just talk about how it's used and how it can be a powerful tool for gifting for most people, especially if you don't need all the assets you have. You can gift in some creative ways to avoid having to report those gifts on returns every year. There's some ways that you can give gifts without having to report those to the IRS. So for gift taxes, every year, every person, you can give an individual up to $18,000 is the annual exemption in 2024. It goes up every year. So this year you can give every individual that you want. So all your children, grandchildren, $18,000 tax-free. You don't have to report it on a gift tax return. If you are filing a gift tax return, otherwise you will likely just place it on there, but you don't have to file a separate return for these gifts. Estate taxes, it's just good to understand what the estate tax is and how high it is now and what it might come down to. So estate taxes, it's a 40% flat tax on any assets over 13.6 million per person. So a married couple would be double that. And you can give that money during life or at death. So it doesn't have to be a death time transfer. It could be during your lifetime. And you can port that between spouses. So if first spouse dies with about 7.5 million, and the second spouse could give away 19.72 without having to pay an estate tax. So it's an enormous amount of money that you can gift currently without incurring any sort of tax. There's also a generation skipping tax that really is just when you're giving gifts to grandchildren and skip generations beyond your children. There is a tax on those gifts. Again, flat tax of 40% on any gifts over that 13.61 million. Income taxes, it's just good to understand the function of estates and trusts. Estates and trusts are subject to the highest income tax rates, 37% at anything over $15,200. So that is why many trusts will push all their income out on a yearly basis to beneficiaries if it's held in trust. It's to avoid having that high tax rate within the trust itself and push that income out to the beneficiaries as much as possible, because in all likelihood, the beneficiaries have a lower tax rate than the trust does. And then it's important to note the tax changes that are coming up. We can't guarantee, no one can guarantee what's going to happen with this tax change. but it's just important to understand that it's set to sunset, the estate tax exemption that is set to sunset January 1st, 2026. And we are anticipating that if it sunsets, it would come down to about 7 million per person. So it would reduce to about 14 million combined. So it would reduce by more than half, or about half. So just something important to think about. So if your assets are close to that 14 million, you might want to talk about doing some tax planning in addition to estate planning. It's just something to think about and be aware of. Gift planning. So there's several ways that you can give gifts, you know, in other ways other than the 18,000. We talked about the annual exclusion. You can also give gifts for education, medical expenses, or give to charity. So again, we talked about that annual exclusion gifting, but you can also fund education for children or grandchildren. You can give to 529 plans, or you can give directly to the school. So if your grandchildren are in private school or in college, or your children are in college, you can give money to those institutions directly without incurring any sort of gift taxes. Gift taxing, it won't count towards your gift tax exemption. You can also pay for medical expenses the same way. You just have to pay those medical expenses directly to the care provider. And then lastly, charitable gifts. You can give to charity. That also helps if you have a taxable estate to give to charity. It reduces that estate. And then if you, during your lifetime, most people don't know about this, but if you during your lifetime have income that you don't need from your retirement accounts, if you're taking required minimum distributions or RMDs and you don't need all that money, or all that income, you can reduce your taxable income on a yearly basis by directing some or all of that income to a charity. It's called a QCD, a qualified charitable distribution. So just something to think about. It might not be something that you are able to do, but just be aware that it exists in the event that you decide to make any sort of charitable gifts during your lifetime, or if something were to happen. And then in estate planning, I always like, with my clients, I like to focus on planning with flexibility. It's really important. Our circumstances change, especially with ALS, you know, circumstances change, our living situations change. So it's important to build in that flexibility to make sure that that estate plan functions as long as possible, and that it is a functioning estate plan that can function when maybe your capacity changes or your financial situation changes. And then it's important, like I said, building in that flexibility. We do that in different ways. It's important to revisit that estate plan every 5 years. I say at least every 5 years, or when you have a major life change. Major life changes are situations such as birth, death, divorce, change in your family circumstances or dynamics, change in relationships in the family. It's important to let your attorney know that that change has happened so that they can make sure that your plan takes that into account. And just remember, a trust isn't always necessary. I talked a lot about trust today. They're a really great tool, really great vehicle for transitioning assets, but you don't have to have a trust, and it might not make sense for your scenario. And when we're planning with children, it's important to make sure we name a guardian so that there's a guardian to take care of those children if they're younger. And generally with children, it's best to have a trust because they cannot inherit those assets or that property when they're minors. Life insurance, it's just important to make sure we remember if we have it. If we don't have it, we should try to have some in place. And if we have it, make sure that you have a beneficiary designated on that life insurance. And then just some of my final thoughts are, you know, this is kind of a rough outline of what your estate plan should look like. So if you don't have children, it would be powers of attorney, financial and healthcare, living will, HIPAA releases. a will, and maybe a trust, just depending on the circumstances and what your finances look like, how complicated your assets are. And if you have children, it's the same estate plan. You just want to also have a trust as well in that estate plan. And that is everything I have today. So I really appreciate the time and the ability to have this conversation with you. And I'm happy to answer any questions that might be in the chat. I have my contact information here. You feel free to save it. Feel free to reach out to Jerry if you want my contact information. I'm always happy to answer questions, have a conversation with you. I know it can be a challenging diagnosis, challenging circumstances, and I know you will all, have challenging times ahead of you, but feel free to reach out if you need anything at all. My firm, we have offices throughout the Midwest and East Coast, and I'm licensed in Massachusetts and Ohio. And we have to put this disclosure up by having this webinar. We don't create an attorney-client relationship. And I can't answer specific questions about your personal situation, but I can answer questions generally about planning. So I'll leave this slide up if you want to jot down my contact information if you want to reach out. But Jerry, if we have any questions, I'm happy to go through those and answer those.
Yes, Erica, thank you so much. We do have a few questions, so I am going to bring them up. The first one, excuse me, the first one is, what are the tax-free limits for Ohio and federal?
So I'm assuming that question is talking about the estate tax limits. So Ohio, we are very lucky. We live in a state where there's no estate tax anymore. There used to be, and I think the year 2013, the Ohio legislature made a really great decision to get rid of it. And so we don't have an estate tax. So you can pass unlimited amounts in Ohio, but you are limited federally. So the federal estate tax limit and it's gift tax and GST tax, it's all combined. So estate, gift, and GST tax is the 13.61 that I talked about. And you double that for married couples. So it's double the exemption. If it does sunset in 2026, it will come down to about 7 million per person, 14 million combined.
So I know you had said that you couldn't answer specific things, so I'm not sure if this next question, but I'm going to give it a shot.
Sure.
The person said, my home deed was changed from my wife and I as owners to only me. The reasoning was for the markup valuation upon my death. Was that a good idea?
So I cannot answer that question
Okay.
because that's a personal estate planning question.
Okay.
And depending on the state you live in, I might be able to answer that, but I can't do that unless you're engaged as a client. It's for,
Okay.
um,
Very good.
it's for
Understood.
conflict reasons. We can't I can't give advice over a webinar, but that's a good
Okay.
question and one to either we can chat about potentially, or you can reach out to your attorney and ask them that question.
Okay, and I think that person is in Ohio, so that might work in the future for everybody. So the next one is, we have a document called 5 Wishes where many things are spelled out. It covers the person I want to make care decisions when we can't, the kind of medical treatment we want or don't want, how comfortable we want to be, how we want people to treat us when we are incapacitated. What are your thoughts on the 5 Wishes document?
I have never heard of that document.
Okay.
So I really can't give any guidance on it. I don't know what it looks like. It might just be guidance. And so the important thing is if you have that document by itself, it might not be valid. It depends on the state you live in
Right.
and that. But if you have that, there's nothing wrong with having that. I like the concept of having those wishes spelled out, especially for your agents to make decisions. You just have to make sure you also have those healthcare powers of attorney and living will and all of those in place. And then if you have that 5 wishes, you can say to your agent, here's what I spelled out for you to use in making those decisions. And I can't think of a situation where a family member would not honor those wishes unless it was physically or medically impossible.
So and you're right on, Erica, because I do believe there are some states that 5 wishes works in. I think I'm not going to try to quote what states they are, but I love it because of the fact that it starts conversations. It's an easy way to start, like you said. So the next question is, do you have an office in Virginia?
So we do not have an office in Virginia, unfortunately. It if you want to work with me, you can reach out, and what I can do is with clients who live out of state, sometimes I'll co-counsel with a local attorney. It just depends on what your situation looks like and whether that, financially makes sense. But I do that with clients. I have clients who were in Ohio who move out of state. I still work with them and I will just work with someone locally. I may have someone at the firm who's licensed in Virginia. I would honestly just have to look. We probably do.
Okay. So the next one is, and this I actually think is the last one. The New York Times had a story a couple weeks ago that the cost of ALS nursing care can cost $40,000 a month, which would wipe out a family's fund before Medicaid kicks in. But I heard that using a trust, and then in parentheses, don't know if that is revocable living trust or asset protection trust, in Virginia must be at least 5 years old for the Medicaid look back to accept the trust funds are protected. As the ALS patient may only have a 5-year longevity, what kind of trust do you need to protect the funds immediately? That was a mouthful.
That was a couple questions in one, but that's
Yeah.
okay. I'll work through it. So that's a common question I get is about, especially when you're dealing with progressive illnesses that are very expensive. And I think honestly, 40,000 is probably on the low end of care, especially for ALS. I have seen clients with, with ALS or family members where the care is well above 100,000 a year. It's a very expensive illness, and depending on whether you're having ventilation or other medical care, it can get the care can really skyrocket. Medicaid planning is very complex planning. I don't really do it anymore. My client base has me to the point where I'm too busy to handle some of those Medicaid clients. But I do always say you're in Virginia, you need to work with a experienced Medicaid planning attorney because it has to be done in an exact way for it to work, for the plan to work. And that's because there's federal law that dictates Medicaid as well as state law that dictates how Medicaid is administered. So Medicaid laws are federal laws, but they're administered by state agencies, which means they're interpreting the federal law. And sometimes the interpretations, I shouldn't say sometimes, a lot of times the interpretations differ state to state. So I don't know what Virginia law is, but in Ohio, it's similar to what you described, the 5-year look back period. And typically it is pretty difficult to protect assets. Typically it's pretty hard to protect assets before that 5-year look back period expires. So I would really suggest that you reach out to a qualified Medicaid planning attorney, and you can do the Medicaid trusts are usually always irrevocable trusts, meaning you put money in, you get it out of that person's name. You typically don't have access or ability to touch that money. And there's a lot of things to think about when you're making decisions like that. So it's really important to talk to someone who's very experienced. And if you want to reach out, I'm happy to guide you in how to find that person who has that experience. I can give you some ways to search for that person, but it's not a decision that should be made lightly because you are giving someone else all of your assets in order to protect them from Medicaid.
Okay.
And
Thank
they're also, and Jerry, I'm not done, sorry. You should also think about if you're married, it's a different consideration because that spouse can keep some assets under Medicaid planning. So it's really, you really have to it's a lot of calculations that the attorney runs. And it's a complex decision of what to do and where to move assets.
Okay, so this is actually the last question.
Okay.
This person missed the beginning and they said, did you talk about what to do with physical gold and silver? What if someone doesn't want to list it in the will or trust and they already passed and you don't know when they got it?
I did not talk about physical gold or silver. That I would probably need more information, and I can't give specific advice about what to do with it if the person's already passed away. But physical assets, you might be able to pass it through that memorandum of personal property if the person's still alive. If they've passed, um, it really just depends on what estate planning documents they have in place, how that physical gold or silver would pass.
All right, Erica, thank you so much. I think that's all of our questions. I want to thank you for your time and just taking the time. I know you're busy and everything, and thank you so much. It's definitely a valuable topic. So everybody, we will be back next month on February the 22nd, Thursday at 1 o'clock, and our topic will be about the decision to get a trach, explaining what it is and all that stuff. Erica, thank you so much. May the weather pick up a little bit better where you are. Thank you, and you have a good day.
You as well. Thank you so much for having me, and it's nice to meet all of you. Thank you for spending some time with me this afternoon. I really appreciate being part of the ALS Association and giving back some of my time.
Thank you so much.
Of course.
Everybody have a safe day. Thank you.